All right. Welcome back to the third video. Let me get myself entirely ready. There we are. So our topic today is unconscionability doctrine. Let me bring up the PowerPoint slide. So we will talk about unconscionability doctrine. Let's remind ourselves where we are, right? Our plan is, we've said, is to look at offline contracting first, then compare modern online contracting. We looked last time at clauses that shift liability, and now we turn to unconscionability doctrine, another of the traditional doctrines that limit what businesses can put in a contract, right, where you know people are not going to read the contract or not, and would not understand it if they did read it. So let us take a look. Let's make sure that we're good. So here's the doctrine, right? And unlike the doctrines we looked at earlier for the various types of clauses, exculpatory clauses and indemnity clauses and waivers of liability, those doctrines apply specifically to those types of clauses. Unconscionability doctrine is a general doctrine, applies to any clause or to the entire contract, right? And it has two requirements. There must be a lack of meaningful choice. That's the first requirement right here. And the term in the contract must be substantively unfair. So those two requirements, and we'll understand them by one of the classic cases used to illustrate in unconscionability doctrine, Henningsen versus Bloomfield Motors. So a couple, you see the facts on the slide, a couple buys a car, steering goes out after less than 500 miles. The car, Mrs. Henningsen's driving the car at the time, car veers sharply off the road and she is injured, right? Now, can the Henningsens sue the car manufacturer and the car seller for compensation for the injuries based on the fact that the steering was clearly defective? Oh, that depends in part on what the contract says. There'd be no issue at all, right? If the contract just said, so to speak, sold one car $2,000 or whatever the price was. It's an old case, so $2,000 is probably about right. Then they could recover for breach of warranty, right? Warranty just being another word for promise, breach of a promise, because the car is a good, a tangible, movable item, and the Uniform Commercial Code applies to goods, sale of goods, and it implies what's called the warranty of merchantability in every contract for sale of goods. That's just the warranty, the promise that the car will be fit for the purpose for which a car is ordinarily used. And clearly the Henningsen's car was not fit for the purpose for which a car is ordinarily used, meaning driving around roads without having the steering go out. So that would be fine, but that's not what their contract said. Their contract had a disclaimer of liability that limited the manufacturer's liability. So it said in part that the manufacturer would not be liable for personal injury, the type of injury sustained by Mrs. Henningsen. It says that in so much legalese, as we'll see in just a minute. But the gist of what it says is, hey, if you get injured, right, you break an arm, break a leg, have internal injuries because something went wrong with the car and it was defective in its manufactured, that is not our problem. We are not liable for your injuries. And there's no general rule that says you cannot do this, right? Indeed, you can, and almost all the contracts we enter as consumers do, but there are limitations. And we saw specific doctrine about this earlier in waivers of liability, but that doctrine is a part of the broader doctrine of unconscionability, which applies to all types of terms and contracts. We've taken a waiver of liability as our example, and here is the clause, right? You can see, it is worth at least looking at the first part. that part of the point of quoting clause is just to focus on the legalese, but there are no warranties, no promises express or implied, right? No promises written down in the document or implied from what we've written down that make either the dealer, the people, the retailer they bought the car from, or the manufacturer of the car, right, liable for any problems with the chassis parts or parts therein, right? So we won't be liable for anything that goes wrong, except, right, and then comes, except that we will replace or repair defective parts, right, within certain limitations. And this is, and then again, they disclaim all the warranties, right? So yeah, well, look, if the car is defective and you get it back to us within 90 days, right, and has not been driven for more than 4,000 miles, then we'll fix it for you. But we won't pay for any injuries, right? And then as again, they say at the bottom, we just put in bold, and there's nothing else that we're promising. That's the waiver, as I say, not untypical of consumer contracting. But here the issue in Henningsen is this unconscionable? Can they enforce this? And the court says, no, it's unconscionable. Let's review remind ourselves of the doctrine again. We need a lack of meaningful choice, and we need substantive unfairness. So let's see the court's view. The court's view is to have both of those at Henningsen. Let's see why they think so. That will illustrate the doctrine for us. So, was there a lack of meaningful choice in the formation of the contract? The court says, well, yes, right? We have a standard form, no negotiation contract with what the court describes as a gross inequality in bargaining power, right? So we got the contracts we've been talking about, standard form, no negotiation. That limits your freedom. And the court say, look, we all know what happens in this negotiation. You have the experienced car dealer and the manufacturer, and with more legal sophistication than the customer, and you have the customer unfamiliar with legal requirements and only buys a car every so often, right? Not entirely familiar with the transaction. And if you ever tried to purchase a car, at least in the US, they use a lot of high pressured techniques, right? The salesperson will outline the deal for you and then say, well, I'll go ask my manager if we can get it, right? And the manager says yes or no. It's all it's all planned out as a little scenario. And there's no real negotiating power for the consumer. So to begin with, we have that. We have the standard form, no negotiation contract. And then it says, look, the court says the Henningsens didn't read the clause. Nobody drew their attention to it. And it was printed on small print. It's printed in small print on the back of the form, right? So nobody in their negotiation said, oh, by the way, Mr. and Mrs. Henningsen, turns the form over and says, see this clause? This means that if one of you is injured because of a defective part in the car, we don't have to pay. Nobody did that. And then they wouldn't have understood the clause if they read it, right? You have to have some legal training and sophistication to understand what this means. So they didn't read it, wouldn't have understood it if they did read it. And all new car dealers use the same contract. The contract was written by the Automobile Association of America and all the new car dealers and new car manufacturers used it. So that means the Henningsens can't go anywhere else to get a better deal, right? The Henningsens can't say, gee, we don't like this deal in this contract, and go down the street and buy a car from somebody else and get a different deal because it will be the same deal. So the court says, gee, there was a lack of meaningful choice, right? It's a lack of meaningful choice. So they can't get a different deal, and their choice isn't guided guided in the appropriate way by the information, right? That isn't guided in the appropriate way by information. So, for example, if if I say, well, here, let's play Rush, but at least in the US we call Russian roulette, right? Here's a loaded pistol, and here's a pistol without bullets. Here's a pistol full of bullets, here's a pistol without bullets. You choose and pull the trigger. You choose, point one at your head and pull the trigger. Your choice. Your choice is free, but not meaningfully free, because you don't have any information about which gun, which pistol has the bullets. The Henningsens are like that. They don't have information to guide their choice, so not meaningfully free, and indeed no options out in the market anyway. So, in unfairness, is the clause substantively unfair? The court thinks so. This is just a straight out normative judgment by the court. It's not anything else. The court just decides it's unfair, and the US courts have decided it is unfair to disclaim liability for personal injury. You can't do it, right? And a quote from, I gave you a quote from the court in the slide, but a way to think about it, what lies in the background of this quote is, think about who puts the product out into the market and benefits from its sales, the dealer and the manufacturer, right? And they put them out there all the time. Who is in the best position to find out about defects in this product? The same person that's benefiting from its sale. The ordinary consumer is not going to do an examination of the steering of the car and detect defects, right? They don't have the techniques, they don't have the access to the steering, they don't have the understanding, they don't have the time to do that, so they're not going to do that. Only the manufacturer dealer is going to do that, check for hidden defects, and they're the ones that benefit from selling these things, so it makes sense to have them bear the burden of checking for defects and pay when hidden defects injure people. That is basically the argument behind it. So we have both, we have both, right? Lack of meaningful choice to review, because the standard form, no negotiation, right? We've got lack of information, so not meaningfully guided by information, and no market alternatives. So that gives us our lack of meaningful choice. And then we've got the substantive unfairness, which is the normative, straight out normative judgment I mentioned, but plausible, right? Look, the person in the best position to discover these defects ought to be the one that has to discover them, or be liable if they don't, especially since they're the ones making a profit off of the product. So again, same point we made when discussing liability. These doctrines, right? We got the rules on exculpatory indemnity and waiver clauses, and now we've got the general doctrine of unconscionability, of which the other earlier rules are special cases, right? And all of this limits what businesses can put in contracts, but as we said before, doesn't provide much guidance to the consumer entering a contract. They help at litigation, and they only help entering the contract, at least if you have some reason to think the business is abiding by the legal requirements. How would you know that? But our next doctrine, next video we turn to a different limitation that actually provides some guidance to consumers at the time of contracting. And this one is the one that turns out to be critical for online contracting. It's the one that plays the key role in online contracting. And one reason I began with the exculpatory indemnity and waiver clauses and unconscionability is for the contrast between those doctrines which help at litigation and this doctrine which helps at the time of entering the contract. So that does it for unconscionability. We are ready to turn to our next doctrine, as I said, plays the major role in online contracting.